Thank you all again for joining us today. We're excited to share some information with you regarding the recently expanded Mortgage Modification Mediation Program here in Arizona. Our esteemed panelists have each handled MMM matters over the last 6.5 years since the program's inception, and we're pleased to share our knowledge with you today. Just a little bit of housekeeping before we get started. As we've mentioned, please make sure your name, not your phone number or iPad, is showing on your Zoom sign-in so we can be sure to get you CLE credit. The session is being recorded for future viewing purposes, so we do ask that you please keep your microphones muted during the presentation. You're welcome to type any questions that you have during the presentation into the chat here on Zoom, and we'll be monitoring that. To the extent we can insert those questions into the presentation, we'll do so. Otherwise, we'll hold them to the end of the presentation, and at that point, we'll open it up for a Q&A session. The materials for today's session are posted on the ACBC website. As always, they've also been placed here in the chat function on Zoom. We'll put them in the chat box again in a little while, just in case you just recently joined or for any that joined here momentarily. Towards the end of the session, we're going to put the CLE certificate for today's presentation in that Zoom chat, excuse me. So if you can't see the PDFs of materials as they're being placed there, please let us know. Put your email address into the chat or send us an email at admin@acbcforum.org, and we'll email the materials and the CLE certificate to you. With that said, I'll do a brief introduction of myself. I'm Krystal Ahart. I'm the co-executive director of ACBC along with Diane Drain. I'm a member of Kahn & Ahart PLLC. I've had the pleasure of working with James Kahn for more than 20 years. I'm not old enough to do that, but it's true. I'm a consumer debtor attorney handling all chapters and enjoying handling MMM cases when they come to me. So we're going to kick off the presentation with some MMM success stories for you. And with that, I'll turn it over to Ellen.
Okay, hi. I'm Ellen Lawson. I'm a solo attorney with Ellen K. Lawson Attorney at Law, PLC. I'm not a bankruptcy attorney. I'm a real estate attorney, but I've been doing loan modification work since 2009, and I've been very active with the MMM program since it started in 2017. I do get appointed as special counsel or mediator in the MMM program, and I enjoy it very much. So we wanted to start off with some success stories of the loan modification program. And in front of you is a chart from an actual MMM case. There were pre-petition arrears of over 22,000. You can see the old loan terms before the modification. There was a variable interest rate that got modified to become fixed. That's very common that happens in a modification. The interest rate was lowered, and the monthly payment was lowered, but it was actually even more lowered than how it appears, because initially the old loan payment of $2,373 was principal and interest only. The new payment of $2,191 is principal, interest, taxes, and insurance. So it really became a more affordable payment for the homeowner.
Hello, I'm Gary Stickell. I'm a sole practitioner. I'm a co-founder of Arizona Consumer Bankruptcy Attorney. I was the chair of an ad hoc committee that requested that the court actually consider extending the Chapter 13 program for MMMP to there are other chapters for individuals. This slide, while this, I asked that this case be included. Ellen did the hard work of getting the loan modification done. You can see how favorable the terms are, but the significance to me of this case is this is a Chapter 13 case that I was having a very hard time getting confirmed. It had a lien strip that was contested. It had administrative fees around the value of a business. And Ellen did not file the loan modification in this case until month 51. So it just shows you how flexible doing a loan modification within a Chapter 13 just adds to the flexibility of what can be done with a loan modification.
So my name is Lisa Thompson. I am the co-chair of the CLE committee for ACBC, and I was on both committees that created the MMM program. And I'm a solo practitioner practicing in all types of consumer bankruptcy. This, I think, might have been one of the first MMMs filed in 2017. This was a client who had been in Chapter 13 for 2 years already and had tried to get a loan modification on his own, and he was unable to do so. But once we filed with the MMM, we were able to bring everyone to the table. What's not shown in this slide, so he was in a 13 and he was having to pay $20,000 in pre-petition arrears to save his house. So I was constantly getting the motion to dismiss because he just was having a hard time making it. We ended up with a no interest deferral of about $28,000 in a balloon payment. And so if the house was sold, it would need to be paid, but otherwise at the end of 2057, he would have a balloon payment, and hopefully in the meantime, we could refinance, and I will tell you that he has done so. So that's my success story.
Thank you, all three of you. This is my success story, also filed really early in the program. I was fortunate to perform my activities as special counsel in this case, and we'll talk a little bit more about that later on. The plan was not feasible or confirmable without a loan mod. Similar to what you've heard from Gary and Lisa, the plan had been pending for some time. There was just a lot of struggles going on over there. So through the loan mod process, which was not painless, but certainly at the end of the day, it was a benefit. We were able to reduce the interest rate just a little bit. Remember, this was back in 2018. So I might not find that so much anymore, but we also fixed that variable interest into a fixed rate of interest, which is certainly a benefit. I'm guessing that their payment would have drastically increased in the years following in light of that variable interest rate that they had. And also, as you can see, that total payment went down $860 a month. So although the maturity date was extended 10 years, which was a little painful to the debtors, I pointed out that the savings each month, you know, if they do the things that they should be doing and do it right, they really could kick off those 10 years really easily with the $860 per month that was saved through this loan modification process. So it's a good story at the end of the day. And with that, I'll turn it over to Lisa. You got 4, awesome win success stories. Lisa will talk to you about the overall statistics.
Thank you, Krystal. I think that some of this is also about survival. So, you want to make sure that you get your clients in a place where they can move forward now and hopefully fix some of the things like the balloon payment later. But look at these statistics. So since 2017, 483 motions for referral have been filed. 62% have been successful. It has been very uncommon for lenders not to participate in this program. I think that it was like 8 cases where the lender said that they wouldn't participate, which is only 1% of all of them. And if you ever get that to happen to you, file a motion to reconsider. Sometimes I think it's lenders don't really understand what it is that they need to do, but most of the big lenders are participating in this program, and you can most certainly see the list. So in 2022, we only had 23 motions for referrals. 2023, 18. There's been none filed since this expansion that went into effect at July 1st. But I'm sure that that's going to change. And I think the statistics or the numbers that were filed during pandemic time or as we're coming out of pandemic time are just going to increase. But 62% is pretty good. So, Ellen, it's up to you now.
Thank you. So I want to just go through really some of the basics. For those of you that have never gone through the MMM program was put in place to give debtors the ability to communicate directly with their lender. Before the MMM program, people would file a Chapter 13 and they would really be on their own to try to get their loan back on track, their biggest asset. And back in the day, it was very difficult for homeowners to get a loan modification. They would fax in all their paperwork, something would be missing. They just tried to get a complete package, and it was very challenging for them. The great thing about the MMM program is they have this online portal that is always visible. All the documents get uploaded. Everyone can see those documents. There's no debate as to which documents have been provided. and it gives a debtor a great transparent opportunity to communicate with their lender and try and bring their loan current through a loan modification. So it's a wonderful thing. The online portal is very user-friendly. And again, it opens up the communication between the debtor and directly with the debtor's lender. So as part of the MMM program, the debtor is required to make an estimated monthly payment, or EMP payment, every month into their Chapter 13 plan. So the Chapter 13 plan payment includes an estimated monthly payment. With the expansion, and as will be discussed in more detail in just a bit, for Chapter 7, 11, or 12, the debtor is going to need to deposit monthly an estimated monthly payment into a separate bank account. The deposit of an EMP is significant every month because it gives the debtor's lender assurance that the debtor can make a payment. It's a way of saying, look, I can make an estimated monthly payment. So, please know I will be able to make a trial plan payment if you offer that to me. Okay, so the EMP is calculated under our MMM procedures as being the lesser of 31% of debtor's gross monthly income minus monthly HOA fees, or the regular monthly mortgage payment, whichever is less. And in the MMM program, the debtor is entitled to up to 2 one-hour mediation sessions during the program if needed. So the MMM sessions, the mediation sessions, are telephonic. The debtor, debtor's counsel, lender, lender's counsel, and the mediator all attend by phone. And they're set up to discuss any problems that occur during the MMM program. The typical one being there's been a trial plan decline decision. So it's an opportunity to understand why the decline was rendered, what can be done. But even though it says the word mediation, typically trial plan payments are not negotiable. They're take it or leave it. But again, there are a lot of good reasons to have the mediation sessions to give the debtor direct communication with their lender during the mediation session. And then, sorry, I should have added, there is a registry of there's a registry of court-approved MMM mediators for bankruptcy counsel to choose from. And that's on the Bankruptcy Court website. Okay, and then there are requirements from the Chapter 13 trustees. So trustees Russell Brown, Ed Maney, and Diane Kearns all have required Chapter 13 plan language for the MMM program. And that is part of the materials being provided. But be sure to look at that chart, because there is literally quoted verbiage that needs to be put into the plan, and it differs according to the trustee. Also, what's important is when a trial plan is approved or the loan modification is approved, those orders approving the trial plan and the loan modification need to be emailed to the trustee. So this chart has the trustee, the chart has the email addresses of where to send in those orders.
And just to dovetail on a couple of those things, the matrix also shows where your fee orders should be sent. So as part of the MMM process, there typically are 2. If it's successful, there are going to be 2 fee orders. And those need to be promptly, if you want to get paid promptly sent to the trustee's office. And there's a particular place that you should send those. So that matrix is very helpful. It shows up at the last page of your materials here. And then also just a note back on the portal that Ellen mentioned, the communications and documents in the portal are confidential. Only the parties to the MMM program are able to see those communications. So it's transparent, but only for those that are in the program and participating in it. Just a little bit on the MMM history. As Lisa mentioned, the program started here in February of 2017. Gary Stickell and Lamar Hawkins had a little idea, started brainstorming. Diane Kearns and Tammy Johnson were absolutely instrumental in bringing the program to fruition here in Arizona. Bob and Tammy Branson from the Middle District of Florida started their program there many years ago. We'll see that in just a second. And they came here in 2016 to train both the mediators and the attorneys for, what is this program all about? And they did that right before the program debuted in February of 2017. And then the committee, most recently, a committee was formed to expand our program. When the program was first introduced in 2017, it was exclusively available to debtors in Chapter 13. But there's been a push on the Consumer Debtor Council side to try to get more availability of this program. And so ultimately the court agreed and formed a committee of about 12 to 15 attorneys. We've got a list of their names at the end of our presentation, just as a quick thank you to all of them. We worked hard. There was a lot of committee meetings and documents and procedures to review and revise to get this expansion done. It was a lot of work, but we're happy to have done it. There are a number of jurisdictions that have the MMM program. I was able to find a number of them that started out with the full expansion, if you will. They started out not only in Chapter 13, but also the program was also available in Chapter 7. And as I mentioned, the Middle District of Florida, the Bransons, that's where the Bransons came from. Their program was started in 2017. So they had been doing it for a good 6 years before they came to train us. And then some other districts have had their programs in place for a while. I was interested to see New Jersey started in 2017 with, I think, all chapters, but Chapter 7 specifically was removed from the program in 2019. So we certainly don't expect that is what will happen here. And there may be others. I didn't do a thorough search for them, but it's good to know that we're not on the first cusp. I've heard Tammy say that she thinks that our procedures may be bigger and better than the other jurisdictions that we've looked through. We really did work hard to make that the case. So hopefully that's true. Expansion of the program to other chapters offers greater flexibility. As I mentioned, it's just now available in 7 and 11 and also 12, but you're not going to hear much about Chapter 12 today, certainly. But I think most of the same rules are going to apply in 11 or 12. Some cases, from 2017, some of our consumer cases were filed as a Chapter 13 because the MMM program was available in a Chapter 13. And that's not really looking out necessarily for our client's best interest. I think many of those cases have since been converted to a Chapter 7 hopefully after successful MMM, or in some cases dismissed. It's unfortunate though that a debtor would have to start with a 13 just for the purpose of getting into this MMM and then have to convert and go through the steps again in the Chapter 7 case. So thankfully that is all resolved. Now we can go back to deciding which chapter of bankruptcy is best for each client under their particular circumstances and enter the MMM program under that chapter if that's appropriate. So that's good news. And a little preview of my warning, right? It's important to inform your clients that this option is out there. I think modification has to be considered. We've got an ethical obligation to consider all available options. And even if we don't feel competent to help client with a avenue, a path, I think we have an ethical obligation to let the client know that this path is out there. It's a potential, and to refer out if need be. I think it's malpractice to not at least consider this as an option when your client is facing mortgage arrears. But do not fret. Help is available. ACBC is always here to help, at least for our consumer debtor attorneys. We do have a 2-hour CLE coming up on Wednesday, August 30th at noon. Of course, will be by Zoom. ACBC members only, plus their staff. We welcome staff to attend this one. It's going to be a real deep dive on the MMM, including walking counsel through our step-by-step guide for debtors counsel. Ellen and I, when the program first came to be, or maybe shortly thereafter, really went through the procedures and created what we hope to be a nice, easy to follow step-by-step guide for debtors counsel to use as they go through the program. You can see from the materials, one of the items of materials that we've uploaded for you today is the MMM procedures from the court website. I didn't look for a page count, but there's a lot of pages. There's a lot of information in those procedures. And of course, it's important that you follow all those procedures and that you're making sure your client follow all those procedures. So again, we've done what we can to do that in a step-by-step fashion, and we'll do a 2-hour training on August 30th. So ACBC members, I encourage you to sign up. Now, if you really just don't want to do it yourself, know that there is special counsel available that can assist your client through the MMM program if you just don't or can't do it. I personally, as I mentioned earlier, have performed my duties as special counsel. So has Lisa Thompson and Ellen Lawson. I know that's just a minimum. I'm sure others are doing it too. If any of our attendees today are offering their services as special counsel for the program, we welcome you to place a comment in the chat about that. If you are going to do it yourself, know, as I mentioned briefly earlier, it can be a lot of work to get to a decision. So it's not for the faint of heart, if you will. And you have to make sure, again, you're following all of those procedures in order to get paid, which we all want to get paid, at least what we can. The procedures, the attorney needs to certify that all the procedures have been followed, and they'll do that in the form of their fee application. The procedures provide for payment to counsel of $2,500 once a trial loan modification agreement has been reached and signed or declined, and a declination decision can be appealed, can be discussed at a mediation session. So at the point when all of that is exhausted and the declination is firm and it stands, counsel is still entitled to that $2,500 payment for good faith efforts to get it done. But the goal, of course, here in all these cases is to get to the final loan mod. If you can get to the trial, generally you can get to the final as long as the client can make the payments. So achieving that final loan modification agreement will result in an additional payment to counsel of $500 after that final agreement is executed and filed with the court. And then there's also a provision for reimbursement of costs. The fee, it is a flat fee according to the procedures. This amount did go up it went up $500 when they made the recent changes to expand the program. According to the old procedures, the total payment was $2,500, so it was $2,000 plus $500. Now it's $2,500 plus $500. So we were pleased to see that increase. Ellen? Oh, sorry, Lisa.
It's okay. Lisa. All right. So what happens if you're in a Chapter 7? I do want to mention that all of the forms that you use in, like we're talking about getting a motion to refer and getting an order and all of that, these are standard forms that are on the Bankruptcy Court website. So you're not recreating the wheel. You're plugging in fact, our success stories, that's a matrix that you use when you're getting your order approved. So we didn't, that the forms are fillable PDFs and you can file them that way. There's also a separate ECF entry for, at least I'm guessing it's going to be MMM. It used to be Chapter 13 MMM matters. And I'm mentioning this because I'm going to talk about deadlines for 7s. So because they're standardized forms and because there's a separate entry, I think everybody here who's done amongst us, like a lot of MMMs, the order for referral gets signed like that. So you better be ready to get going. So typically I don't do it until I'm already ready to go, because the deadlines do move very quickly and you have to have your package in within 7 days of getting your order. So requesting a referral to the MMM in Chapter 7 must be done within 45 days of filing the petition, or 30 days after you get an order converting from another chapter to a 7. So that's a pretty tight window. And then within 14 days of getting the referral, and this is what I'm talking about, you will get the order of referral very quickly. Within 14 days, the debtor must make an EMP payment, and that can either go to debtor's counsel's IOLTA account or special counsel's IOLTA account, or the debtor can set up his or her own EMP account, and Gary's going to talk about that later as to whether or not that's a good idea. Within 30 days of filing for the motion of referral, you have to prove that not only do you have an account, but that those EMP payments are being made, that the deposit is being made, and you must continue to do that every 30 days. And so the proof of the deposit, the document that shows that you made that EMP payment within 7 days of doing that, has to be uploaded to the Bankruptcy Court portal. Next slide, please. And so, like I said, 7 days. The EMP deposits remain in either counsel's trust account or the debtor's EMP account until there's an order from the court dispersing those funds or directing how they're going to be dispersed. And you know, I didn't list out all of the things in section 8D, but I mean, essentially you're going to have an order dispersing funds when attorney's fees need to get paid, because one of the reasons why we have the EMP is so that there's money to pay counsel. So there would be an order saying attorney's fees get paid. You would get, for like trial loan modification payments to be made, you would be able to get an order when final loan modifications need to be paid. And then once, if for some reason it's not successful, then there will be an order returning the funds to the debtor and also allowing counsel to be paid. One other thing is, if the debtor doesn't show proof of payment within 7 days of the deposit, like that monthly payment, then the lender may seek relief from the court. So this is a thing that really needs to happen. And next slide. So the other big thing and the consideration that Gary's going to talk about is, while you're in an MMM program in Chapter 7, you will not get a discharge until the MMM proceedings conclude. So whether they're successful in obtaining a loan modification or if they fail, there will not be a Chapter 7 discharge until such time as there is a final report filed by the mediator. So that is certainly a consideration that Gary is going to talk about in regards to these. And just a side note, we're not really talking about Chapter 13s here, but it's sort of the same thing as Chapter 13 plans can't get confirmed while you're in an MMM. It just doesn't happen. You have to either, you have to end your MMM proceedings before you can confirm the plan. So this is sort of the Chapter 7 equivalent. Next slide.
Actually, I want to make a quick note on that.
Oh,
I
I'm
wonder,
sorry.
no, that's okay. I wonder if that's about to change in light of that Evans decision and the trustee not being
It
able
could
to
be.
pay him or herself.
You know what? I think you're right.
Yeah.
I bet that's going to change. But as of today,
yeah,
if you're watching this in years to come, today is July 28th, and as of today, you cannot
Yep.
confirm the case while you're in the MMM.
Exactly. What's different in Chapter 11? I was surprised to see no timing requirements. In Chapter 7, Lisa just mentioned to you that you have 45 days to enter or 30 days after conversion to 7 to enter, and there doesn't seem to be any such rule in the Chapter 11 section. Well, I guess to say that for the next, there's no requirement to establish a separate EMP account. I was also surprised to see that. Now, in Chapter 11, as some of you know, all bank account activity is outlined in detail on a monthly operating report. So it's not like debtors' funds aren't visible to the court and other parties. But still, I think the establishment of a segregated EMP account is really wise. I think it really helps to set our clients up for success. So I don't know if that was intentional or not. In fact, I sent an inquiry along those lines to see about that. So maybe we'll see some more changes in that regard. Plan confirmation, similarly as we were just talking about in Chapter 11, is going to be delayed. And the reason for that is that final loan modification must be incorporated into the plan. If loan mod fails for some reason and the debtor just can't get it done, then maybe the surrender of the home needs to be incorporated into the plan. So whatever the outcome is needs to be achieved before the plan in a Chapter 11 case can be confirmed. And then the last bullet here really applies in Chapter 11, 12, and 13. The trustee can see those portal communications. So trustee is one of the required parties involved I shouldn't say involved because they're really not terribly involved, at least not in Chapter 13 cases, but they can see the communications on the portal. So it's important to know that. And now I get to turn it over to Gary for his special considerations you've been getting previews of.
Yeah, thank you. So once again, I want to just reiterate the importance, and I would say the ethical duty of debtors' counsels explaining to the client with a mortgage arrearage, especially a very large mortgage arrearage, the availability of the loan modification program through the court. The other thing I would say is that for me, it was an easy thing to suggest to the court expanding it to Chapter 11 of individuals as well as individual folks doing subchapter 5 now plans. the one that I was more skeptical about was Chapter 7, just because it changes kind of the nature of the discussion in a Chapter 7. Basically, and that goes down to the key thing here is that you're going to be telling your client to understand that their discharge is going to be delayed until the loan modification process is over, one way or another, approved or not approved, for a final loan modification. And this obviously creates logistical issues for your clients. So in a Chapter 7, as previously described, you have 45 days. It is the only chapter where you have a set time frame for filing the petition for loan modification. But 45 days, I mean, that's a week after most meetings of creditors. So, I mean, you're a good 35% through the plan. I mean, you're going to get, the discharge is going to happen in 90, in 80 some days after that 45-day period. So, it's, in my mind, you really want to make sure your client starts doing loan modification as soon as possible after the filing. Plus, as somebody I believe said, maybe Krystal, you have all the documents. The same documents you're going to put into the portal are the documents you use to fill out the schedules, and they should be fresh. And because you're having this delay of discharge, you're also going to have a delay of the closing of your client's case. And that's why, one of our considerations that we're pointing out is you may want to consider seeking or doing a motion to abandon that house. I mean, if you're doing all this work to help the client keep their house, the last thing you want to do is have the trustee, checking out the increased equity value of the house and the client losing the house or having to make a deal on enhanced equity. And we've seen way too much of that over the last couple of years. So, nowadays I've been asking trustees just to abandon it without filing the motion. But otherwise, you're going to need to file. I would suggest if you file this, you want to also file a motion to abandon as well. So, sorry, I'm looking at my notes here. The other burden is trying to set up how does your client report these payments. Either debtors counsel or if you hire special counsel. And I am not a special counsel. I'm the only member of this panel who does not do these as part of their gig in life. But I highly recommend hiring special counsel, because what I learned doing these early on is I don't know what I don't know. And these folks, these very capable folks on this panel do. They understand this process. And personally, I would not allow my client to be the person who sets up this separate account. I would have it set up in my trust account. The trust account allows you to be aware of what's going on with it. And plus it gives you a chance to make sure there's money in there at the end of the day to pay your fee. So let's look at a chapter 7 real quickly as to the benefits over doing it with a chapter 7 versus a 13. And one, you don't have to commit to that multiple chapter 13 plan. I mean, if there's no other reason to file a chapter 13, and Krystal mentioned this at the outset, then you don't have to file one. And the nice thing about, and so you're not in the situation where you're converting or dismissing the case. And if the client has a car payment, anyone that's helped a client out converting or dismissing case know how screwed up the car payments get. So if you can do a 7 and do a loan modification, the car payments are going to be current, and you don't have to worry about that hassle. The second thing is the Chapter 7, these conduit payments are not being, these are not being paid as conduit payments to the Chapter 13 trustee. So therefore, your client's not getting a surcharge of 10% on the payments made to the Chapter 13 trustee. As you know, and this is my segue to Ellen and an answer to David Brown's question. You still may want to do a Chapter 13 because a mortgage modification may result in an increased interest rate, while a reinstatement in Chapter 13, should be able to keep that interest rate. But once again, I don't know all the ins and outs of that, and that's why I turn this over to Ellen.
Thank you, Gary. So one of the things I wanted to talk about is today's current interest rates. So right now, the interest rate on a 30-year fixed mortgage is greater than 7%. So the challenge from a loan modification standpoint is if a lender approves a homeowner for a modification, will they honor the existing interest rate, or under their guidelines, are they going to raise the interest rate to today's market rate, making the payment that much higher or unaffordable? So that is a challenge. And so what I wanted to make everyone aware of is there's another thing to consider, which is Arizona's Homeowners Assistance Fund, which is referred to as HAF. It was established in 2021 to replace Arizona's Hardest Hit Fund, and it was set up during COVID to help with a debtor's homeowner's mortgage delinquency. It also gives assistance for HOA delinquency, property tax delinquency, and even utility debts. The cap on HAF assistance is $40,000, and it does not need to be paid back, which is an amazing thing. There's an online application, and it's, again, very simple and straightforward. There are documents that are required, but it's a much simpler process than what happens in the MMM program. The HAF program, the HAF assistance, can be used for reinstatement or in conjunction with a loan modification. It's absolutely something to think about if, let's say, you have a client that just had a loan modification 2 years ago. Are they likely to receive another loan modification 2 years after? If they're not a good candidate for loan modification, or they just had a recent loan modification, or if they were declined on loan modification because the delinquency was too high, then HAF is absolutely something to look into for your clients. And then next slide. The main HAF eligibility criteria, which is also on their website, is the homeowner's income needs to be under 150% of county median income. The financial hardship has to be tied to COVID and have started on or after January 21st, 2020, and HAF assistance is only for primary residents. So keep in mind that if someone has mortgage delinquency that started in 2019 and then continued on into 2020 because of a COVID hardship, HAF is only going to be giving assistance to missed payments that occurred on or after January 2020. So that is something, it is focused on COVID hardship.
And we have, sorry, our next slide is just the helpful links, but I'm going to save that for a moment and go back to one of the questions that we had in the chat from Andrew, just to dig into some of the background a little bit more. His question was, if the loan mod is declined, and I assume he means in a Chapter 7, and then the debtor needs to convert to a Chapter 13, what happens to fees if not already paid? And I know some of the presentation after that question came in, I hope helped to flush some of that out. The establishment of that EMP account, or perhaps more appropriately the IOLTA deposits, the EMP deposits into counsel's IOLTA account are going to be the funding source for the attorney's fees that get approved by the court. The EMP payments, remember, start right away. 30 days after the debtor enters the Chapter 7 MMM program, debtor has to start depositing those EMP payments either into the IOLTA or into that segregated account. And in most cases, I think all of us have found there are at least a couple of payments, maybe a few payments, maybe more than that, that get deposited into that account before we reach the point of a trial loan mod or perhaps a full-on declination that we can't get past. Right? So in most cases, there's a nice little stash of cash available for attorney's fees. And you heard Lisa mention that at the end, whatever happens, if it's a declination that you can't overcome, then the order for your fees gets entered. And I don't know if it's part of that order or another document related to the MMM, but the procedures provide that once the fees are paid out of that segregated account by the debtor or out of the IOLTA account, that the remaining funds be returned to the debtor in the case of that declination. And I think under Section 348, effective conversion, if you started in a 7, the funds in the bank at the petition date of the 7 are what matters, not at conversion date. And Gary, I'm sure, can correct me if that's not right, or somebody else. Any other thoughts on that question, or otherwise? Yeah, go ahead, Lisa.
Well, I think it's important if you guys haven't been doing MMMs in 13s, and that's still an option. I mean, we just now can do it however we want to. But I think one of the good things is just because you can't get your plan confirmed, again, as of today, while you're in the MMM, you will get paid fees. And they actually do, at least Diane Kearns distributes them. Like as soon as you get that order, it comes out mid-month, which is really nice to have that happen. So, you know, they're really trying to, and your trial loan modification payment, if you're successful, is going to start like a month after you get that letter. So all of the money that you've put in the EMP account, which in my opinion should be your IOLTA account if you're in any other chapter than a 13, that can be used to pay your fees. So you're protected in that way. Sorry, Gary, go ahead.
Well, no, and the unpaid, you know, because it is a court order, you know, in a Chapter 7, and you know, if you convert to a 13, it should be treated as an administrative expense. It is a court order. You should be able to get any balance unpaid as an administrative expense. If you're the debtor's attorney and you've been representing the debtor in an you know, MMMP, did I do the right number of M's? I'm always bad about that. But if you do, you know, if you've done that, yeah, there's no reason in my mind you don't take the money as you're converting it. But you know, if it's special counsel monies, you know, it should be distributed. It should be pointed out in the Chapter 13 plan that these administrative fees have either been paid pre-confirmation or ordered by the court, and it should be done, you know, treated as any other request, you know, as any other kind of pre-petition fee or a fee that has been agreed to pre-petition but not paid. So I mean,
Pre-conversion.
what do you? Yeah.
You mean it's the pre-conversion?
Yeah. I mean, do you
Gary's
agree,
also
Andrew? Do you see any problem with that?
You're welcome to unmute yourself now, Andrew. And the rest of you, if you have questions, put them in the chat, or you're welcome to unmute and speak up. Andrew here still?
Okay.
Maybe not.
This is David. Can you get a principal reduction to bring you with the higher interest rate? Can you get a principal reduction to bring you down to 31% of the income? So say I'm going at a 7%, but I want my payment to equal 31% of my monthly income. Can I get a principal reduction or principal deferment to get me there?
Ellen,
So I'll address that. So, you know, over the years, I have seen some principal reductions, but honestly, that was like many, many years ago. I'm not seeing any principal reductions now, and it's not realistic to expect that they will offer any principal reductions. The challenge with the high interest rate, I probably should have expanded more, is even if lenders want to work with the current market interest rate and it makes the monthly payment higher, they still might, and I use the word might, they still might offer that to a homeowner because it's a way to get the loan back on track. There are lenders out there that if they calculate things with today's market interest rate for today, and the payment is higher than the existing monthly payment, those lenders quite often will say, well, you know, we could qualify you for a modification, but the payment is higher, and because it's higher, it doesn't meet our guidelines and we can't offer it to you. I know that sounds really circular, but some investors and lenders will only offer a payment if it's lower than the existing payment, whereas others will offer a higher payment and just let the homeowner decide if they want to take it or not. So I don't want to scare people. It's not that lenders only gravitate to the existing current market interest rate, but some do. And you just won't know what their guidelines are until you've gone through the entire process to wait to see what they offer.
And on that note, I think it's super, sorry, Lisa, but it's super important to talk to your client about that. I mean, you need to have a CYA letter that confirms to them that that may be part of the solution package. And the package is what it is, as Ellen mentioned. You know, there's not a lot of wiggle room in trial loan mods. For the most part, they are what they are. And you know, the lender takes their guidelines into account. We can never know what those guidelines say. They're very secretive about that stuff. So, you know, your client needs to be fully informed that their interest rate may go up as part of this package. They can choose to accept or reject and decide what their backup option is, but they should be fully informed that that may be part of it before they move forward.
Ellen, just as a follow-up, so on the HUD loans, are they not offering that silent second anymore, where you can just dump it back into like a silent second that you don't have to pay until you refinance yourself?
So yeah, no, I think they still offer that. So for HUD government-backed loans, they can offer what's called a partial claim, which really means a second lien. They are still doing that. And I know for like VA loans, they did a lot of that for VA loans where they offered forbearance. Then they would take during COVID, then they took those missed forbearance payments and just put it into what's like a partial claim is what they call it, but it's really a second lien. So it's not principal reduction, but it's just a deferred amount put into a second lien that's non-interest bearing, that's due when you sell the home or when the loan matures.
So that's something you would look into for a HUD and a VA if your clients have those.
Yeah, I would. Yeah. So the partial claim deferral on forbearance payments for VA loans, that program has come to a stop since we're so far out. I think the automatic putting it into a second lien ended like October of last year. I might not be exact on that, but if it's a government-backed loan, I would still absolutely anticipate that they could do a second lien partial claim on the loan today.
And just to clarify, David, the lender does all of that in the background and tells you what they're willing to provide. It's not like you, debtors counsel or special counsel, get to go to lender. I mean, I guess you can always ask, and say, we would like this to be part of the package. That's just not how it works, right? The debtor prepares, with counsel's assistance, hopefully, a nice package of their financial information to show that they can feasibly make a monthly payment, that their budget's in line, you know, provide bank statements, provide tax returns for cross-checking information, et cetera. And then you leave it into the lender's hands to tell you what their guidelines will allow them to do. And in my experience, as I mentioned, it is what it is. And I keep jumping over you, Lisa. Let me get right to you. Go ahead.
Yeah.
So
I had Judge Collins make them explain that on one of those, those agricultural loans to South Levine, where they had this special secret underwriting that they did. Judge Collins made them explain that to us, how they came to that decision. And I did get that one modified, by the way.
Awesome.
So, yeah.
Lisa.
So what I was going to say is that's the purpose for the mediation, because if you're doing it outside of this program, you're kind of guessing at what their parameters are. Like, you really don't know. There are no federal, I mean, there is no HAMP anymore. All of that sunsetted, years ago. And so when even if your client's declined, you can have a mediation, and it's not, let's make a deal. It's, hey, what were the parameters? And what is it that we need to do to qualify? Did you use the correct income? Did you consider this? Because a lot of times you submit your package, and I had one that was my personal one where my client, we didn't put a mortgage payment in the package on the financial statement because it was a conduit plan. So the mortgage payment was included in the bankruptcy, and they said my client didn't have enough income. Well, they didn't when they added back in the mortgage, right? And so once we had the mediation and we had a conversation, and it's not confrontational, it's like, hey, what number did you use? Oh, you used that. Where did you get that? Oh, well, and you figure out why your client was declined if they were. And sometimes, you come up with a solution. I had a mediation that happened to, a couple weeks ago where, okay, there was a dialogue. And I've had some where my clients were declined and my clients felt okay. Clearly they wanted the loan modification, but they didn't have the fear of missing out, because we got on the phone with the lender and we said, what are the parameters? And they said, these are the parameters. And we looked at them, we discussed it, and we don't meet the parameters. They're not getting a loan modification. And so they at least knew that they had done everything that they could, exhausted every opportunity, and they were going to either have to surrender their house or pay their arrearages in a Chapter 13, period. So I think that this is how you get information. And I do think that it's malpractice not to have let your clients know about it. And if they don't want to do it, that's cool, but make sure you cover that, because, you don't want them coming back saying you didn't do something. So that's all I had, Krystal.
Yep. Thank you. And thank you for your patience. Another good question in the chat from Andrew. Can a debtor in Chapter 7 begin the MMM and simultaneously use the HAF program? And he goes on to say, it seems HAF could relieve the debtor from the increased interest rate on the MMM through the MMM. Ellen, you want to speak to that?
Yes. So interestingly, I had a client who applied for HAF funding at the same time she was trying for loan modification. She got declined on the loan modification, and she was not in a bankruptcy, but she got declined on her loan modification, and then realized she wanted to use the HAF funding towards reinstatement. And she was able to work with HAF, because when HAF renders you eligible for the 40,000 funds, they don't know if it's for reinstatement or in conjunction with loan modification. So they kind of allow it for either scenario. So obviously people want to try for loan modification and get HAF funding, if that makes sense. And in her situation, she got declined on the loan modification, and then we were able to work with HAF to redirect that just for reinstatement purposes. But I guess to answer your question, Andrew, yes, you can. I don't see any reason why you can't apply for the MMM program and HAF assistance, because it can only be a good thing. If I have a client with $50,000 in delinquency and they can get $40,000 in HAF assistance, then all of a sudden they're really asking their lender, can you modify me with $10,000 in delinquency because I have $40,000 coming from HAF? So there is coordination, and maybe we'll talk about it in our next seminar as well, but HAF communicates with the lender, with the lender's HAF department. So there's internal communication from HAF to the lender on a portal, and it's using codes. And part of the problem and challenge is HAF will communicate a question over to the lender and needs the lender to promptly respond back. And some of these lenders take weeks or months to respond back. So you have to take a very active role communicating with HAF and the lender to coordinate them back and forth. But I can tell you there's a real willingness to offer the HAF assistance. They are very motivated. And if there's a pending trustee sale date on the property and you give them that notice of trustee sale, they will bump that half case to the top of the list. And they're very open about that. So they are trying to help as many people as they can keep their homes. It's a great program.
And I think to the extent we catch clients early enough, send them the halfway ASAP, especially if their delinquency is under that 40,000 mark. That certainly, maybe can solve the problem outside of bankruptcy, certainly outside of MMM. So if possible, I would recommend jumping on that as quickly as possible. And if you need to, then jump into a bankruptcy and an MMM as well. That way everything is kind of put on hold at the same time. We do have some helpful links in your materials. As I mentioned, of course, the HAF link is there. Also, the portal that we lightly mentioned, the link for the portal is there. And then the link for the procedures and forms, including the mediator list, is available on the court's website there. Contact information for the panelists is here. As always, disclaimer, and special thanks to all the people on the committee, including Lisa Thompson, who apparently missed the list the first time. I apologize, Lisa, but there were a lot of people working on the committee to expand the program. So we thank everyone for their hard work in getting this done. We hope this program is a success. We hope you will not be fearful of it. We hope you will attend ACBC CLE if you're a member or staff on August 30th at noon. That's going to again be a 2-hour deep dive into just how we do this. So we welcome you to please register and attend for that. The page isn't quite up, but you'll be receiving email notifications soon. Last chance for questions. Otherwise, thank you, Jim. Hello, Diane. All right. I did post the CLE certificate in the chat a couple times. Hopefully you were able to see that. Grab that. I'll put it one more time just so it's on the bottom there. Grab it before you depart, please. But otherwise, you're welcome to leave and have a nice afternoon. There it is.
Thank you, team.
Yes, thank you, team.
Yes, thank you.